Thank you so much for having me here. And I would like to thank all the organizers and also everybody who is involved in running this conference. I learned a lot today, and I also hope to share with you my research. So I just start by telling you a little bit about my background. My background is in law. And then at the point when I was doing my PhD, I started to do interdisciplinary research. And ever since I finished my PhD, I have been continuing doing interdisciplinary research because that is something I really enjoy. And over time, I have been looking at a variety of different social problems. And for the past years, I have been looking at the issue of discrimination in the context of organizations using artificial intelligence as part of the decision-making process. And before I go into the detail about concrete legal solutions that I have been working to develop and about the concrete obligations which exist on states to govern individuals who design and use artificial intelligence technology, I actually want to start by talking about equality more broadly, because I think that really to address issues of inequality, we need to consider the problem holistically, and we really need to look at the global level. So, for example, there are scholars such as Abeba Berhani who talk about the fact that the use of artificial intelligence produces impacts at the societal level. And these impacts are not always easy to detect. So some of these impacts are going to be invisible. So this is something important to realize. But even if we don't go as far as discussing the invisible impacts in today's presentations, I want to link my presentation to the presentations which took place before me, because sustainability is very much connected to the issue of both equality and inequality. So to give you an example, if we look at the news reports, we know that climate change is happening, and we know also that communities are being impacted in different ways. And scientists are already forecasting that those countries which are surrounded by water are going to suffer to a great extent and will feel the effects much sooner than countries which are not surrounded by water, for example. And we know that some countries may go underwater and people will be fleeing and will need a new place to stay. So obviously there is already inequality because some people will not have to leave their country and some people will. Of course, there is also the issue of food insecurity, with some countries having more resources to be resilient, and other countries have fewer resources. And so I think that the work that many individuals in this room and elsewhere are doing in terms of sustainability is actually very important for ensuring equality. We also need to think about equality more in geopolitical terms. So, for example, Usal Sahbaz has been writing about how the use of artificial intelligence can exacerbate inequality on the global level, and how some countries may undermine the human rights of their citizens because they will be taking steps to collect more data because they would want to be using artificial intelligence as a way to equal their position on the geopolitical arena. And we also know from news reports that some big companies which produce computing products have much bigger budgets than some countries. And so I think when we talk about artificial intelligence, we are talking about equality and inequality, and these issues of equality and inequality are very much intertwined with many aspects of our daily lives, many different types of policies. And so I think that we should be mindful when we think about what kind of technologies are we developing, what kind of problems we are solving using artificial intelligence, that we really need to think about how is technology creating change at societal level, and we also need to be tracking these downstream effects. And there are also entire disciplines which are have been dedicated to looking at how technology is changing society, human psychology, urban design, and so on. So it's not like we are starting from ground zero. I think I just want to re-emphasize that to really understand artificial intelligence and how it's creating change, we need interdisciplinary teams, because I think it's very difficult for one person to actually have expertise in all the areas and to contribute all the knowledge which we need. So having individuals with different expertise who talk to each other is really, really important. Now I want to move on to talk about really to give you a little bit of context for my own work. So the context for my work is that states are parties to international human rights law treaties, and essentially these treaties are agreements where states agree with each other that they all have certain kinds of obligations. And we also have many human rights treaties. Some of these treaties are global in character, meaning that there are countries all around the globe which are party to these treaties. So, for example, the International Convention on Civil and Political Rights. We also have some human rights treaties which are regional in character. So this means that countries from a specific region would be party to this treaty, but these treaties wouldn't be open to just any country located anywhere around the globe. So an example is the European Convention on Human Rights. And these treaties do have similarities and differences. So from the perspective as a legal scholar, when I talk about legal protections, I actually need to be talking about a very specific treaty because, for example, the prohibition of discrimination can be framed in somewhat different ways depending on what international treaty we are looking at. But it's also the case that there are numerous international treaties which formulate the prohibition of discrimination in a similar way. So, for example, we have ECIDO, which is a treaty prohibiting gender-based discrimination. We have ECIRD, which is the treaty prohibiting race-based discrimination. We also have ICRPD, which prohibits disability-based discrimination. And all these three treaties define discrimination in a similar way. However, there are also important nuances because, as you can imagine, when you have an entire international agreement that's just dedicated to protecting people from discrimination on the basis of a particular protected characteristic, then there are certain nuances in that treaty that are designed to capture the fact that people can experience inequality in a distinct way. So at this stage, I want to say that the work that I'm doing would have a relevance for these three treaties. But for example, there would be much more work that would need to be done to see to what extent it's applicable, for example, to the European Convention on Human Rights. And the starting point for my project was that when we saw that artificial intelligence, well, it's a technology that is rapidly evolving, and certainly countries and organizations are now starting to spend a lot of money on research and development. And we also see a situation where there's an explosion of use cases where literally some organizations are interested in using this technology in lots of different contexts. And from our standpoint, as lawyers and legal scholars, by the way, I'm not a lawyer, I'm a legal scholar, just to make it specific, because I'm not licensed to practice in the UK. From our standpoint, the difficulty which we were facing was, well, the legal rules which we have, states drafted them with the idea of people or organizations, and these rules, states never really designed them with artificial technology in mind. And artificial intelligence is a very complex technology. Not only is it complex from the standpoint of technology, but also there's a lot of work being done on the way in which the use of artificial intelligence can produce downstream effects which wouldn't be obvious or apparent. Both for individuals and communities, states, and globally at the interstate level, for example. So when I started doing my research, there were two directions which could be pursued. So one could be looking at how we could develop international legal rules which we have at the moment in a way that accommodates the distinct aspects of artificial intelligence technology. And the second route was to develop completely new legal rules for artificial intelligence technology. And I chose to go through the first route. I just want to mention that the Council of Europe is drafting a new treaty which is specifically designed to govern the development and use of artificial intelligence technology, and there will be a new definition of the prohibition of discrimination in 2025. And I am following this work with interest, but the path that I chose to pursue was really based on the fact that we know that it takes a long time for states to reach agreement. We know that states can be making all kinds of trade-offs in the process because states represent a variety of different stakeholders. So I was very much interested in developing a solution so that people are protected while states are negotiating, for example, with creating new treaties. So I just want to highlight that the work that I'm about to present, I really tried to be as comprehensive as possible. But of course, I'm not saying that my work addresses absolutely every aspect there is. And I also want to mention that the use of artificial intelligence technology, we know that this technology has very diverse applications, and that in some cases there have been real breakthroughs. For example, there have been discoveries where a chemical substance has an application for different medical need. But we also know that in the area of protecting people from discrimination, we see a real problem because we see these recurrent cases where people are disadvantaged by the use of artificial intelligence technology. So, for example, the Dutch government resigned a number of years ago because the tax authorities started to use artificial intelligence to flag potential fraud. And what happened was that individuals who were religious, for example, and ethnic minorities would be, first of all, inaccurately, but also disproportionately flagged as a fraud. And the consequences for these families who were flagged as fraudsters or potential fraudsters were devastating, because some of these families filed for bankruptcy. Some of these couples ended up being divorced because they couldn't handle the stress of the situation they were in. So the impacts were very, very much significant and very much devastating. And this is not an isolated case. So we see repeated cases where people experience exclusion. So another case was in the United States where an employment lawyer started to do an investigation and found out that an artificial intelligence system that companies use for employment would essentially advantage candidates with a specific name, Jared, and candidates who play the specific sport lacrosse. So here we see arbitrariness. Yes, I see you laughing, but it's real, because obviously one's name has absolutely nothing to do with how well qualified someone is to perform a particular job. So given the circumstances in my research, I really focus on the risks, and I focus on how we can protect people as comprehensively as possible, given the fact that that we do have particular treaties that formulate state obligations in a particular way. So today, of course, we don't have the time to go through all the provisions of a treaty, but in essence, the definition of discrimination is quite open-ended. So the focus is on whether there is a distinction between people or exclusion of people or restriction of people from enjoying human rights on an equal basis. And the focus is on how the action or the measure has either this purpose of distinction, exclusion, or restriction or effect. Now, the definition is very open-ended. So what I decided to do was to look at scholarship, very much theoretical scholarship about what should count as discrimination, why is discrimination wrongful. I took that scholarship and I showed how the treaty can be interpreted so as to incorporate the scholarship as an additional test for discrimination. So this test it fleshes out what this definition means. And then I showed how very specific rights can be derived from this test, which can be embedded into the existing treaties. So first I want to tell you about the test, and then I want to explain what kind of rights can be derived from the test. So under this test, whenever an organization or a person uses an artificial intelligence decision-making process, there is discrimination in the following circumstances. First, if it puts individuals in a situation that is inequitable. And here I use the scholarship of Martha Feynman, and she would define what it means to have inequity in the following way. So she argues that all of us are vulnerable because everybody can fall ill, for example. We can all be in a situation where there is a natural disaster, and so we need, for example, assistance to help us to overcome and to be resilient under very difficult circumstances. And so Martha Feynman argues that to account for this vulnerability, the state has to structure relationships between individuals and institutions in a way that enables individuals to access resources on an equal basis. So she lists a variety of different resources, such as education, unemployment, natural environment, for example, religion, art, essentially resources which we need for our human to realize our human capacities. And in terms of what another example of an inequitable situation, I take from the work of Martin Scheinin, who would say, well, there is inequity if you put someone in a position of inequality in relation to others. The second limb of the test is there is discrimination if the employment of artificial intelligence decision-making processes impedes the ability of individuals to define their identity and to decide how to express their identities. And this limb of the test is based on how discrimination occurred historically, because what would happen is that a dominant group would ascribe certain characteristics to a group which was disempowered in a way that didn't actually reflect the identity of that group and how that group understood members of the group understood themselves. So, for example, with gender, we know from the work of Marshall McLuhan, who talks about how historically, up to about the 20th century, men would talk about women as emotional and irrational and hence incapable of reaching sound decisions. and that was a justification for excluding women from being lawyers, for example, or from being doctors. And of course, since men portrayed themselves as, as rational, that would make them appropriate candidates. So of course now these stereotypes are much, much weaker, and we do have much greater inclusion of women in different domains. This is just an example of why being able to express and define one's identity has such a crucial role in safeguarding equality. So the third limb of the test that there is discrimination if the operation of the artificial intelligence decision-making process creates disadvantage. This is very much based on the work in discrimination, because as Tarun Khaitan points out, after examining different non-discrimination provisions in different pieces of legislation, the purpose of these protections is actually to address the fact that some groups experience a really serious and pervasive disadvantage in society. The fourth limb of the test is based on the work of Martha Feynman. There is discrimination if the operation of the artificial intelligence decision-making process prevents individuals from being resilient and really realizing their potential. Feeds into the work of Amartya Sen, who talks about human flourishing. Then we have also the fifth limb of the test, again based on the work of Tarun Khaitan. And here the employment, if the employment of the artificial intelligence decision-making process doesn't take into account how structural inequality impacts on the ability of people to access opportunities, then there is discrimination. So what is structural inequality? Structural inequality is inequality which stems from how we organize and run our society. And David Oppenheimer talks about how these different disadvantages are not only embedded in society but intersect. So for example, some individuals have less access to banking. For example, it's harder for them to get a loan because of discrimination. The quality of education that they receive is worse because they live in a poor neighborhood and the school has fewer resources. The transportation is not as good in an area, so it can be, for example, challenging for someone to get employment in a specific place because the transportation links are poor. And let's say someone has childcare responsibilities, and then the lack of transportation can result in a lack of flexibility where someone effectively cannot access a particular job opportunity. We also have information about how in the United States there's a lot of research about how people of color, for example, don't have the same life expectancy, or how women are more likely to not give birth safely. So we do have plenty of research about these really socially embedded inequalities stemming from how institutions operate and from the allocation of resources. And as David Oppenheimer points out, these sources of inequality interact with each other and exacerbate the impact on the individuals. Now, the last limb of the test is based on the work of Deborah Hellman. And whenever the use of artificial intelligence decision-making processes operates in a way that creates either a new type of disadvantage or exacerbates a historical disadvantage, there is also discrimination, and hence the use of these systems are unlawful. And an example when the use of an artificial intelligence decision-making process creates a new type of disadvantage can be seen in the work of Sandra Wachter, who explains how the operation of artificial intelligence technology can create new disadvantaged groups. For example, because someone owns a dog, because someone plays video games, or because the way that someone uses a mouse to browse the internet. So historically, for example, people who own the dog wouldn't experience disadvantage, but suddenly with artificial intelligence, we see these new groups. So I think that what I really add is that I derive many rights from this test. And these rights are not just rights for individuals, but they also give rise to specific obligations for states. So one of these rights is that individuals can object or just say no to the use of an artificial intelligence decision-making process. They don't have to explain why they're doing that. They can just say no. This is the case even if there is a human being overseeing the operation of the artificial intelligence system. And what is really significant for persons with disabilities is that they don't have to invoke the right to reasonable accommodations. So this is a right that anyone would have without having to invoke an additional reason. They would just have to have a protected characteristic. Now, another right that's really important is that developers have to obtain informed consent from people before gathering and labeling their data. So we know, for example, from the work of Kate Crawford and Trevor Paglen, that these decisions about how to label data, they are subjective, but they also have political significance as well as a cultural significance. And so the idea here is that developers would need to be working closely with the affected communities and would have to ask them first of all, for permission to get the information, but also we'll have to consult them about how their data comes to be labeled, but also how they come to be represented in the mathematical model. People can also contest, for example, correlations that the artificial intelligence detects. So we know, for example, that when artificial intelligence technology detects correlations, it can also detect relationships between different pieces of information or different types of characteristics that people have. And going back to the work of Sandra Wachter, we know that these correlations can be counterintuitive or not very logical to people. So the idea here is that if these correlations give rise to a concern under one of the limbs of the test, then people can challenge them. So for example, if there is a correlation that disadvantages someone, the person can contest the use of that correlation, or let's say this correlation doesn't take into account structural forms of inequality, then people can be contesting that as well. So let's say, for example, we do have a situation identified by Cathy O'Neill where police sends resources to particular neighborhoods because of historically policing has been biased, so there's a vicious circle. So for example, if the system detects a correlation between someone's ethnicity, for example, and someone's likelihood of being in a certain neighborhood, and hence, someone being flagged as a risk of potentially committing a crime, then this person can challenge this correlation, because actually the correlation is connected to our historical systems of race-based discrimination in policing. So people would also have other types of rights. For example, they could contest how the artificial intelligence classified data and allocated their data into a group with other data based on similarity. Individuals can also contest the use of artificial intelligence technology to solve particular types of problems. Because, as we know from the work, for example, of Solon Barocas, there's a lot of subjective judgment involved in determining the problem to be solved and what we are predicting for. And actually, Solon Barocas explains how what we are predicting for, what we choose to predict, for example, how we define what it means to be an effective employee, actually can really determine the predictions and can incorporate bias for many types of reasons. So the example he gives is if someone defines who is an effective employee based on how far that person lives from the company, because the assumption is that if someone lives close by, someone is likely to stay with the company for longer, that there's going to be more loyalty, then actually that kind of these kind of assumptions replicate inequality, because not all people can afford to live close to the place where they work, but also it's really an assumption that someone's commitment to the company relates to the place where they live. Someone who lives further away actually can be even more committed, because they have to spend more effort on a daily basis to come to that company. So the very fact that they are working for that company already shows a high level of commitment. So the idea with this test is that very much it's an overarching framework. So it's not a test that can be embedded into the actual technology. And so we cannot say, well, that there is a way to embed this test into a technology, and then somehow this technology can be certified, as lawful. The idea here is that this is very much a framework that, first of all, imposes obligations on states, including to pass legislation in order to give effect to these types of protections. And secondly, then the idea is that the companies developing this technology will have to comply with certain legal obligations, and then there are certain best practices and guidelines which one can formulate to enable companies to comply with these legal requirements. Now, I don't have the time to go through all the rights that individuals would have under the test that I propose. Today I'm just giving you a few examples, but the idea of this test really is twofold. First is to uphold the autonomy of people, so they can decide, for example, whether to give consent for this technology to be used when they apply for a job, for example. And the second idea is really to give the affected communities as much control as possible over the development stage of the technology. So they would have to be consulted, and not just consulted as a tick box exercise, but very much consulted so they have a lot of input and impact on the final decision. And Equal Rights Trust is an NGO based in the UK, which talks about meaningful consultation. So meaningful consultation in terms of the affected communities actually having that significant input into the decision-making process. And the idea here is that the affected communities would be involved in the decision-making. First of all, what kind of problems are we solving using technology? What kind of problems do we need to leave for non-technological solutions, and what kind of problems are actually appropriate in terms of using technology. Secondly, they would have a lot of input actually into the design process, and they would be able to monitor, for example, and decide what data comes to be gathered, how data comes to be labeled, how the artificial intelligence creates, for example, processes data, how you have essentially the model of the external environment based on these correlations that get to be detected, so the affected communities can actually monitor, okay, what are the different types of correlations that the system detects? What do these correlations mean? What is the impact of these correlations on the actual final decision? And as we know, these decisions are very much statistical estimates of the likelihood of a certain fact being the case. They are not, and we also know from data science in general that artificial intelligence it doesn't produce decisions about people. It uses data about individuals whose data treats as being similar for the purpose of making the prediction. And Linda Taylor is someone who talks about this issue of artificial intelligence not even making decisions about people or the person as such, because of using group data. So then my hope really is that the involvement of the affected communities and the control that the affected communities would have over technology and the input which they would have would actually decrease the risk of problematic uses of this technology and problematic outcomes. Now, I'm very aware that more work needs to be done, for example, on questions such as transparency. So it's a well-known problem. The black box problem is a well-known problem that even computer scientists don't really fully always know, for example, how the system operates, especially with neural networks. We have multiple layers, and then the system updates, for example, the model, as data, as it processes the different layers of the neural network and creates a more granular representation of the data and creates a more granular model of the external environment. So, of course, much more work needs to be done on the questions such as explainability and transparency. My work really hasn't been addressing either of these issues, but of course both transparency and accountability would be very much key to the affected communities being able to participate in the development process, because if the affected communities cannot monitor how, for example, the labeling of data in a particular way impacts what kind of correlations the artificial intelligence detects and what kind of predictions it generates, then their participation is not very meaningful. They cannot form an independent and informed opinion. And of course, there are also other questions such as capacity building, that members of the affected communities would actually need to have knowledge about how artificial intelligence works as a technology to be able to have that meaningful input. So thank you very much, and thank you for your questions, and I'm looking forward to hearing questions and thoughts. Thank you.
Thank you, Tanya. Any questions? Mark?
So thanks, that was a very interesting talk. If I wanted to challenge the use of an AI system in, let's say I was applying for a job, does that not require me to have a lot of knowledge about AI, also an understanding of whatever data is being used? So this is a framework that will mean that things are regulated differently, but in terms of practical challenges, how would you see it being implemented, like for an individual or a group of people to actually raise a meaningful challenge?
Well, I would say that at the moment there is a big barrier so you identify a barrier to access to justice, because what you are saying is a very valid concern that on paper it looks like people have rights, but in practice it's actually very difficult for people to invoke their rights. Not only because we don't at this stage fully have the technology for transparency and explainability, but also because companies want to have intellectual property rights over the models that they are developing. And this means that they don't want members of the general public to actually know, for example, what the model is. How does this artificial intelligence system actually represent the external environment, right? We also have companies saying that people could game the system, meaning that, for example, if someone knows how the bank decides who gets a loan, then people could manipulate, for example, what they input, what kind of information they input, or they can make decisions which would create an advantage for them. So companies say, well, people will game the system, so if you allow people access and understanding about how this technology works, then people will just be, it's like a football game, right? Who can be better at navigating the system, so to speak. And to this concern, I have two observations. First of all, traditionally with human decision makers, we have had transparency. So if I decide to apply for a promotion, then I am shown the promotion criteria, and actually I can plan my career, so I can make those decisions which will enable me to meet those promotion criteria, for example. And from my standpoint, I think fairness actually requires that people have advance notice about these criteria and how different criteria come to be weighed. Because otherwise, what is going to happen is that computer scientists who work on developing these technologies, they will have access to this information. They will be advantaged by this information, and they could be using this information to their advantage, whereas everyone else is going to be excluded. And so I do think that from the standpoint of fairness and transparency, we actually, we need to have that knowledge among everybody about how this technology operates. Now, of course, in practice, it's very challenging to achieve this goal, because we know that these systems use thousands of parameters, and the weighing of parameters can change. So the neural network, for example, adjusts itself all the time as it gets new information and as it generates predictions. And potentially there could also be feedback, for example, for the neural network. So let's say a bank makes a loan, and then the bank sees whether the person repaid the loan, and then that outcome gets to be fed back. So when we have such dynamic systems which are constantly adjusting themselves, it's not the case that you can just have someone who monitors and says, yes, everything is fine. It's also the fact that as the neural network operates, it adjusts itself and changes itself, so we can never really be sure. And I think it's Michael Wheeler who talks about this issue also of feedback loops, that as artificial intelligence operates and adapts itself and gets input of information, actually you can have sort of also reinforcement that some people, for example, who get a positive decision later on because they got a positive decision before, whereas people who were disadvantaged keep perpetually being disadvantaged. So it's not the case that we can just, for example, vet a particular system and say it's fine. It's also the fact that this system would have to be monitored all the time, and we just, we don't have the resources really at the moment, given the current state of technology, to really be monitoring in a comprehensive way what is happening to the artificial intelligence and detecting all the problems. And also it's possible that problems can creep in for different reasons. Let's say, the code gets degraded, right? Maybe there can be minor mistakes that can creep into the code as the system operates, maybe after 5 or 6 years, right? So there could be lots of different reasons about why the actual artificial intelligence can be very different after 5 years in use than when originally the companies started using it in the first place. And I can say that I did contribute to a call for evidence by the UK government, where I talked about this problem that actually for people who are not very, very highly experts in the field of artificial intelligence, it's very difficult to even know when they are being disadvantaged, because they don't have access to the decisions which other people are getting, right? So how does someone know, how does someone even discover that the system, for example, is operating in a way that's entrenching existing inequalities? How does someone know that, how does someone know that they were disadvantaged because they own a dog, right? It's not in anyone's mind that is even a situation that could arise, and unless they are reading very highly, unless they're just reading articles by Sandra Wachter, which most people don't have the time to, they wouldn't even know that this problem exists. So we do have a real problem with what we as legal community call access to justice. It's hard for people to know when actually there is a problem, Secondly, collecting evidence is very difficult, again, because of intellectual property rights or because they can depend on the goodwill of the company to be disclosing evidence, because it can be hard for people to ask about the decisions of other people. Again, we come to the right to privacy, for example. And then imagine how expensive it is actually to go to court, for example, and have all these experts that you need to pay for and all this analysis that you need to carry out. And I can tell you that even without having that, litigation is already very expensive. It's not affordable to everyone. And so we already have situations where people take on a mortgage in order to be able to go to court. And so in a situation where laws exist, but lots of people cannot actually use the benefit of the law, when we are adding more complications for people, I think it is going to be a real problem. And I just want to highlight that the UK government is not addressing this problem. It's at the moment it wants to leave it to regulators to establish best practices that companies would have to follow, but best practices are not enforceable in a court. Unless the judges develop a solution to this issue, essentially people are going to be at the mercy of private corporations, in terms of even following those best practices. And I'm aware now that there is dinner, so I don't want to keep you away from dinner. It's been a long day, so thank you very much for your questions.